It is June 5th of 2026, and this is the Court Gallery. Today's show is full of rage-inducing stories from court. First up, a man is back in court for burglarizing his romantic partner's home again. And Judge Stevens has some pointed thoughts on what makes a man unmanly. Then we shift to a truly enraging and horrid case where a social worker details the web of lies spun by homeless parents with 3 small children, including a 10-day-old newborn. Now mom is in jail and CPS is involved. And we wrap with a family feud that boils over when a woman chokes her nephew's girlfriend for calling her son well, you'll just have to hear it for yourself. It all starts right now.
It's Jacoby Broussard, this call. No answer in the courtroom. I asked the bailiff to call into the hall for Jacoby Broussard, please. He's on.
Yeah, as I figured.
There's a motion to modify conditions of community supervision. How is the defendant doing?
He's doing well. Yes.
Except for the fact he doesn't show up when he's required.
Yeah. I don't think his attorney's here yet either, though.
Yes.
Admittedly.
Good.
I might be.
His attorney's not been on probation. Maybe should be. But he's the one that's responsible for showing up on court order. Yeah.
He did know about it because I
He
talked
did?
to him. Well, he was originally scheduled for last Friday. So when we were reset, I called him and let him know it had been moved to this Friday. Yeah. So yes, I did verbally tell him that last week.
Where's your attorney?
Job.
I know. Where is he? Yeah, me neither. I don't know. He's supposed to be here, but he's coming into Houston, I think.
Well, say for something
Well, last time we were here, he took your CP, this was taken, and he was able to contact some which I have all his reports for that too, because he's in them right now.
All right. Help me out here. There's a motion to modify conditions of probation.
So the last time we were here, the discussion was being placed on a GPS tracker, which he has been on and he has been in compliance with that.
Okay.
The big discussion was whether the defendant was going to be allowed to have contact with his victim. His victim is his wife. Last time we were here, you asked me to contact the CPS worker in charge of the case at the time to get their recommendation. I did, and
it's the victim of the burglary habitation.
correct.
Right.
Yeah.
Ashley.
Yes.
Yes. And so
Wait, she didn't have the same last name as you.
Yes.
Is that right?
Yes.
But y'all are married?
Yes.
How does that work?
She kept for that.
Y'all have different surnames.
Yes.
But y'all are married.
Yes.
Okay. Is that unusual, or am I the only one on the planet that lives a conventional lifestyle? Like, my wife keeps her maiden name, but it's the male's surname. But these are 2 different names. That's what throws me off.
But I spoke
Are
with.
y'all ceremonially married?
Yes, sir. You got married in Las Vegas.
In Las Vegas. Well, that's legal. It's more interesting. Get married there. But okay, that's one way to do it. But there's going to be confusion, at least when the two names are used, and then one says I'm married to him, but we have different last names. That hadn't been a problem at all in your existence? No. Okay, good luck. Well, you can do that. It throws somebody like me off.
Right.
Okay,
I spoke with CPS. I spoke with the CPS officer in charge of the case at the time, and she was in agreement with my recommendation, which was that the defendant should not be allowed to have contact with his wife until after he completes the BIP program. He is currently enrolled in the program.
where are you in that program as far as how far along?
He is almost 2 months in, and I have his progress.
What does that mean? What is the?
About a third of the way through, Jeff.
Correct.
Okay, so half a year.
He has attended 9 of 9 sessions so far.
Okay.
I do have his progress reports here. There have been no issues. He's participating. He's doing well. He's paying, he's attending, he's had no absences. So I am in agreement with her recommendation. She is in agreement with my recommendation that he should complete BIP first, and then he would be allowed to have contact with the victim.
Okay, we'll take it up after the BIP matters intervention protection program is completed. You are here on a burglary of a habitation, right?
Yes.
And in 2013, you were convicted of a burglary of a habitation out of Harris County, correct?
Yes.
Was it the same victim?
No. Different person, similar facts, ironically.
Of interest?
Yes, sir. And it was only because the victim's impact input that I agreed to a probation on this case. But I also made it a condition at the time of that plea that I wasn't going to agree to contact. And all they've done since the probation started is come back and ask for contact.
All right. Let me go back to 2013 on the burglary of a habitation. The victim in that case, was that a romantic interest of yours?
Oh, yes, sir. That's my son's name.
Do you see some kind of a connection here?
Yes.
You burglarized the people you claim you love.
Yes, sir. I was living there at the time, and when we split up, we were living together. We were high school sweethearts. She moved. The situation that happened, and I let myself into the home. This situation here.
No, you burglarized. It's burglary. You were convicted of burglary.
Yes, sir.
Which is entering without permission, breaking. You forced your way somehow into it, which is what we're doing here again.
Yes.
It's as though we didn't learn our lesson the first time. But I went with this on this disposition.
I'm still living in the home, in my home, in the home now. I'm still living in the home.
Where's the lady? That
She's separated. We separated as from
Okay.
court date.
Nice. Well, we're going to continue the order that was placed at the beginning, and let me just read some real quick. Okay.
Yeah, discussion. It's about sign.
All right.
Show up there. See what.
What we have here is a consistency problem that bothers me. But in each of these cases, you were convicted, and in this one, you're convicted. you were placed on regular probation, but you've got a conviction, a second conviction, which means the next felony, you're looking at 25 to life, a habitual felon. Each of these similarly state that you committed burglary with intent to commit assault on the victims. And I'm looking at the probable cause affidavit, which is in this one. I don't have it in the first one, but this one's bad enough to read. And I remember this was very disturbing. Yeah. Kicked in the front door, grabbed her, threw her to the ground, assaulted her with a closed fist. You punched her with a closed fist. Let's see. Injuries were seen to her face, right knee. Then you fled the scene, which was about the most unmanly thing to do in your little black Nissan Altima. And they had to chase you, and they caught you soon enough. And then you tried to evade them. Then you were finally arrested and transported to the police, to the jail. Let me ask you this. You said you're ceremonially married to this lady? When did y'all get married?
2 days after our birthday.
What does that mean?
2 days. April 20.
Well, like I don't know your birth date.
Right.
Yeah.
April 24th.
Of what year?
2022.
Sir?
2000 and I'm sorry, not 2000. 2019. Sorry.
Well, let me read the probable cause affidavit here. It says, police were dispatched to a place in Beaumont in reference to a burglary. The police observed damage to the front door, then made contact with the lady, Ashley, let's call her, who was in the rear bedroom. And speaking to her, police observed damage to the wall, television, bedroom door. And she advised that her ex-boyfriend, Jacoby Broussard, ex-boyfriend, y'all were married.
Yes, sir. We were.
Why is she referring to you as her ex-boyfriend?
I have no idea, sir. We're legally married, sir.
Is that a fact? Does probation?
I
I
don't
mean, this
have
probable
any,
cause
I don't have
that
any
they
document.
write just what is told. Why would anybody?
License.
Why would a married person, ceremonially married, say it's my ex-boyfriend? I mean, that's just bizarre. And listen, and she said, you grabbed her, threw her to the ground, and punched her with a closed fist. About the most unmanly thing you can do to punch out girls. It's not, those kind of people were dealt with pretty severely where I grew up. That you don't punch girls. You don't punch guys. You shouldn't be doing that. But picking on a girl is kind of weak in the character. I don't like this. Second time you've been convicted of burglarizing with assaulting behavior. So we're going to put you through some training that you should have learned when you were a child. And that is respecting others, especially people you claim you love. Well, what do we need to do? Do you only have any contact with this person until I tell you? Do you have a GPS device?
Yes,
so
sir.
we know where you are?
Yes,
What kind of?
we monitor that.
All right. What else can we do?
I mean, he's in BIP right now. He is doing what we're requiring of him.
Okay,
So
anything else we need?
at this point, just, continue to have no contact with her, and then maybe we review it again at a later time once he's completed that program.
Okay, how long is it going to take?
He still has 10 sessions, which is 10 weeks. So I would say at least 3 or 4 months.
Okay, we're going to review it in 3 months. All right, get a resetting. And these are 2 cases here, not only the burglary, but the evading arrest that he was pleaded to. What did we do on Whitney Beck?
She just showed up. Yeah, I thought she was here.
Okay. Come on up. Whitney Beck. Where's Whitney Beck? Come on up. Up on the phone. This is a review,
Yes.
probation review. And, where are we on this? It was scheduled as judicial review from an administrative hearing memo sent to me in March of this year, which alleged several things.
I'm sorry, I'm late. I didn't get a
And
notice.
this alleges well, an uncertain thing about a injurious or vicious habits in violation 2 of your probation order. Failing to obtain court permission to leave Texas. The state testing positive for THC. Really?
Yes.
Failing to remain off the premises of any bar, tavern, or similar place. Failing to perform community service. Failing to abstain from the use of intoxicating substances. Failing to submit to alcohol, drug screening at the direction of the probation office, and then behind in court fees here. All right, what does anybody want to say before I say something about where this should head?
So we requested the judicial review simply because originally when we called Ms. Beck in to speak, it was about simple allegations that we were hoping to intervene with. It wasn't until the original hearing took place and we requested UA and behaviors started taking place in which were not acceptable. However, on that day, she submitted a urine sample that was cold. And so attempting to get that done or redone, a new sample, she began to have anxiety and things, and it just escalated. So we asked her to leave the building and we would come back on.
Today?
Well, this was at administrative level. And we tried to come back again and do the same thing, and we just aren't having success having any conversation with that.
Okay.
So that's what we requested the judicial review for.
Okay. What's they say?
I'd like to hear what you say, Judge.
I want a motion to revoke probation.
Okay, we can get that filed.
We could do that today.
Your Honor, please, that's not half of what is actually true, sir.
That's why we're going to have a hearing and we will see, but I trust my probation office. My probation office has almost a 95% success rate. The national average is 75. They try hard for success on the people, and that's what I want. And I've done this for almost 20 years, and it's always the defendant at fault, not the probation office. Failing to, let's see, I don't even know what that one is. That's a nebulous one. Failing to obtain permission to leave Texas in March. Testing positive for THC, tetrahydrocannabinol, marijuana. Failing to remain off the premises of any bar, tavern, lounge, or similar place. Let's see. Has not completed any of the court, or has she completed any court-ordered community service?
You have to pay for it.
I'm asking her, and then I'll ask you, Miss Budinsky. I can see where we are on this. The tail is wagging the dog. You're on probation, but I know what you're doing. I know what this, you want to be on your own probation terms. See, I know how you are. I recognize this. Go
Your
ahead.
Honor, none of the hours have been completed.
None
if-
have been completed. Okay.
In order for her to pay or to be eligible for a particular program, in order to spend money on community service, she would have to be current on her fees.
You've been on probation for how long?
I'm almost done, almost 2 years, sir.
My question was, You've been on probation for how long?
2 years, sir.
2 years.
Yes, sir.
Zero community supervision, community service, zero. What was this about the failed to submit the alcohol drug screening on February 24th? Tampered and tainted the UA sample. That was the cold urine that came out of her 98.6 degrees body.
Yes.
It's not possible.
You just, once again, you're going to have a chance to speak, Miss Budinsky. That's rude. We learned that in kindergarten. And then owing a balance. Okay. Anything you want to say now? This is your chance. You've been
Yes,
trying to interrupt
I'm sorry.
long enough. But I can guarantee you, cold urine is not a natural
No,
phenomenon.
sir, it's not.
Okay, so it's their fault? Did they do something
No,
wrong?
sir. I'm
Okay.
not saying they did.
Oh.
No, sir. I just know that it's not possible as well.
Okay.
The test strips, don't know what could have been wrong, but they have you pee in a plastic cup, not a one with temperature. And only reason and I never left any state. I have no idea what accusations. I've been going through a custody battle with my son. I had to spend $10,000 recently. That's why I'm behind. I plan on getting caught up as soon as that hearing is done. I have one more hearing. I just got a vehicle. My car blew up in March. I've been having to catch a ride to work. It's not an excuse, but
No.
I've been getting it done.
All right.
Your Honor, we do have a second test that was disputed for marijuana. It did come back from the lab confirmed positive for THC.
Okay. Okay. We've got an anniversary date of this probation too coming up. Right?
That's obligated.
The court is going to order a motion to revoke probation to be filed. Then we'll have a hearing on it and everybody will get heard and we'll figure out what direction that needs to go in. But these are disturbing. And I'm really anxious to hear the story about the urine because this is a science and you don't urinate cold urine. It's your body temperature that comes out. And also the test, the drug test,
The second,
that drug test was confirmed by a more accurate subsequent test, which confirmed the marijuana, which is forbidden.
Most definitely.
All right. Anyway, we'll file a motion and then we'll go from there. Okay. Anything else on that? Get a resetting for review in 4 weeks to see where the motion to revoke probation is. Just I want to review on her for enforce our one.
All right, Ms. Wagner, do we have everybody with us yet or not?
We have most people. I just called the jail and let them know we are ready for respondent mother.
We're simply waiting for the jail at this point. I do see Mr. Jones is with us.
Yes, sir, I'm here.
Thank you. As soon as the jail is available and Ms. Johnson is available, we'll get started. So thank you for your patience.
I know she had another court appointment today with family court or the forensic court due to child support.
Okay.
Your Honor, as we're waiting, I'm wondering if I could be put into a breakout room with my client, as I have not been able to talk to him since this new petition came out.
Ms. Wagner, can you put Mr. Jones and Ms. Hansel in a breakout room, please? Is that you, Ms. Johnson?
Yes, Your Honor.
All right. We're going to be waiting just a minute. Mr. Jones and his attorney are currently in a breakout room discussing this case. Once they're back, then we'll be able to proceed with everybody present on the case. So just be patient and we'll be ready in a few minutes.
Yes, sir. Thank you so much.
All right, I do see Ms. Hansel and Mr. Jones are back. We will continue the matter then of the Jones children. It's file J26-386-NA. We are here today on a protective custody matter that was emergency last night. Was scheduled for today. Mom and dad are both present with us. If I could have the appearances of counsel, please, starting with Mr. Vernon.
Adam Vernon on behalf of the department.
Larry Brown on behalf of Ariel Johnson, who is currently lodged.
Donna Hansel on behalf of respondent father Bradley Jones.
All right, thank you very much. And we also have Ann Sullivan from the department with us today. Ms. Sullivan, I assume, Mr. Vernon, that you want to take some testimony from Ms. Sullivan?
That would be the plan. Yes, Your Honor.
All right, Ms. Sullivan, would you raise your hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you very much. Mr. Vernon, go ahead.
Thank you. Ms. Sullivan, you signed a petition asking for the removal of the Jones children, Estelle and Elizabeth. Is that correct? And Stephen?
Elizabeth, yes, and Stephen, yes.
Okay. And you did the investigation on that before you filed the petition?
I initially did the investigation in August of last year, and then I was just recently reassigned the ongoing case. So it's been an ongoing issue.
And during your investigation, did you have reasonable cause to believe that the children were at substantial risk of harm based on the surroundings that presented an imminent risk of health to themselves?
Yes. The children were at a substantial risk of harm, basically due to the living arrangements.
And what were those?
We were not able to, I was not able to ever verify the living conditions. I had received a couple of CPS complaints this week indicating that the family was living in their car. And as I tried to confirm the living arrangements, there was a lot of deceitfulness and dishonesty. So I was not able to actually confirm that they were not living in their vehicle.
So at this point, do you have any understanding of where the children are residing?
As of today, the children are placed in a general foster home.
So prior to that placement, where was it your belief that they were residing?
I believe that they were residing in their vehicle.
Okay. And did you have conversations with either parent to address that issue?
I did several times this week.
And were they able to provide you with sufficient information to allay your concerns or fears for the children's safety?
They were not.
Would it be contrary to the children's welfare to continue residing in that environment?
Yes. The children are very young. They are 10 days old, 1 year old, and 2 years old. So therefore, based on their ages and their developmental stages, they're considered extremely vulnerable children. So it would be contrary of the welfare of the children to remain with the parents due to the housing situation. And the parents haven't been able to meet the children's basic needs.
And I was going to ask about that. Did you have any information that the children's basic needs were being met?
So housing was the biggest concern, but throughout the intervention since August of last year, there have been some situations in which the parents didn't have like milk for the kids, or the living environment was when they were living in the apartment and in a home, the home was very unsanitary at times.
So even when they were in a home, that home was not appropriate.
Correct.
And when they were in their car, did you have an opportunity to view the car that you believed that they were living in?
I did view the car actually earlier this week. The car is jam-packed full of belongings. The trunk of the car was full. There were several snacks, like I think I saw some Chex cereal, and various items on the floor of the car. The car was pretty dirty on
Was
the
it,
inside.
when you looked at when you saw the car, did it appear to you as though that it was consistent with somebody who was living in that car?
There were several belongings in there. If they were actually sleeping in the car, the parents would have been sleeping in the front seat, and the car, the kids would have been strapped, probably most likely strapped in their car seats or in their car seats sleeping. There wasn't like sleeping space in the back of the car.
Okay. And were reasonable efforts made to prevent or eliminate the need for the removal?
Yes, there were several services that were offered to the family, including the family did have a removal of their children in the state of Kentucky, and whereas they were offered services through the state of Kentucky. The parents' older two children are in what they call a permanent custody with their grandfather. We completed home assessments. Early Head Start was in the home, infant mental health, community mental health services for Ariel. Families First was in the home twice for 2 separate interventions. Families Together Building Solutions. They both completed psychological evaluations. We provided Bradley with funds so that he could get his birth certificate in an effort to get his driver's license. We provided Goodwill vouchers, bed bug kits, pack and plays, diapers, wipes, sleep sacks, food assistance, Medicaid, and NEMSCA provided them with housing resources.
And were those efforts or were those services sufficient to alleviate the housing concerns?
They were not.
And where are the children now?
They are placed in a general foster home in Elmira.
And is that an appropriate and suitable environment to provide for their needs at this time?
It is.
Your Honor, I think that's all the questions I have to ask.
All right, Mr. Brown, any questions that you have of this witness?
Just very briefly, Ms. Sullivan, I had a very brief opportunity to review and scan through this petition. Who is Terry Johnson? Is that Ariel's father?
Yes, it is.
And was there a reason that he could not take the children?
So he will be considered for placement. We have to do a more thorough, we call it a 3130A. So we have to do that before we can place with him. I did have several conversations with him yesterday, and he did agree with that decision. He would be a single caregiver, and he would have 5 children ages 5 and under in his care. So we want him to be as prepared as possible before placement.
And when the children were removed, what was their condition? Did they appear to be malnourished, or were they having physical difficulties?
So Ariel and Bradley actually dropped the children off at our office last night. The children were, with the exception of Steven was wearing like a pajama outfit. They were only in diapers. They didn't have any shoes or any clothing on. The children were covered in bug bites from head to toe. With the exception of Steven, he had clothing on. He did not have bug bites. He had a couple little scratches on his face, probably from scratching himself. They appeared as though they hadn't been bathed in a few days. They are very small in stature children. I wouldn't say they appeared malnourished, but they are very small for their ages.
Did you say that they dropped them off at your office?
They did. They met, well, I shouldn't say they dropped them off. They brought them to me.
Well, brought them to you.
Yes.
Okay.
Poor choice of words.
And what was the purpose that they brought them to you?
Bradley had called the intent. Initially, they were going to go to Ariel's father's home, and that's where they were going to be once if we had received the removal order. Bradley had called me and told me that he did not want to see Terry or have any interaction with Terry, so he was going to bring the children to me.
Okay, so did they do that in order to get care for the children so that they would be properly cared for?
I guess I don't understand what you're asking me. Like,
Why would they bring the children to you?
because I had made Bradley aware that I was filing the petition for the removal. And then after that petition was filed, I told him that I would contact him and let him know if there was a court order for that removal. So then in the effort of making arrangements for me to take the children into custody, the arrangement was
Okay.
he was going to bring them to me, not that he was like relinquishing the children to me. I think that's what you're kind of asking.
Okay, well, how about Ms. Johnson?
I had very limited contact with her yesterday. But she was with Bradley yesterday when the children were brought to the office.
All right, thank you. I have nothing further, Judge.
Thank you, Mr. Brown. Ms. Hansel, questions for this witness?
Are there arrangements being made for any parenting time with my client? I realize the mother is incarcerated, but with my client, Mr. Jones, is he being allocated parenting time with the children?
Yeah. So when he was at the office yesterday to bring the kids, we had spoke briefly about parenting time. I had asked him if he would be available for a parenting time visit today. He told me he had to work a triple shift at work. So the way we left it is he would contact me this afternoon to see about doing a parenting time this afternoon. If we can't coordinate one for today, then we will attempt to do that on Monday.
And actually, I do have time because I actually took PTO, so I can actually see them today.
Excuse me.
Okay.
I had a question for the judge, if it was okay.
Ms. Johnson?
I was wondering, Judge, I was told that I was gonna be set up with a payment plan and be able to be released today. Is that truly the case?
Well,
or?
I think, Ariel,
That's-
you're getting into a different case.
We're going to bring
Yeah.
that up in a little while, Ms. Johnson, but not right now.
Okay, thank you, Your Honor.
Yep. Any other questions, Ms. Hansel?
Just to clarify, if I understand correctly, the children, albeit from the perspective of the worker, they appear to be maybe small for their age, but are, for the most part, they're basically healthy. Is that correct?
Yeah, I would agree with that.
Okay, and that includes the newborn, Stephen?
Yes.
Okay. I have no other questions at this point, Your Honor.
Ms. Sullivan, how long have the children been residing in the car to the best of your knowledge?
The family had to be out of the home on Sunday, May 31st.
And what activities have DHHS, or what services have DHHS provided to the family to prevent them from being homeless?
So we had a meeting with I introduced them to we have a new position in our office called the Family Resource Support. I believe it's an acronym, FRS. And they provide assistance with just obtaining resources. She had met with Bradley and had offered to actually fill out a NMSCA application for him so that they could get the process moving forward for NMSCA's housing assistance. We had, throughout the ongoing CPS case, we had known that there was possibility of eviction. They were waiting for the official eviction notice so that they could qualify for more services. DHS did offer them to apply to help assist to apply for an SER, which is emergency relief. We had also put Families First in the home on 2 separate occasions, and they were helping with obtaining housing because we knew that it was inevitable that the eviction would eventually happen. I met with them on several occasions and had asked them if they had a plan, if they had talked to anybody, just to kind of have a plan in place. I had also talked to Ariel's father. He was willing to take Ariel and the children into his home, but he was not willing to take Bradley. So that could have been an option. So we did assist them with the housing situation. It just didn't work.
And that occurred over at least a 5-day period of time?
No, it actually started, we started looking for assistance with housing back in December. Families First started helping them with housing in December, and then it continued on through the ongoing case. This week, I would say, on Friday, I had met with them along with the FRS worker and had offered them some resources. I also met with them on Tuesday this week. They told me that they were staying at a friend's home, which could not be verified. They couldn't tell me any information about this friend. I had conversations with Terry this week. I met with them on a couple different occasions. I was on the phone with them constantly all week, trying to assist. I was on the phone with NIMSCA this week.
And I actually did hear from him.
Mr. Jones, you can't interrupt. You'll have a chance to speak in the future if you wish, but not right now. Ms. Sullivan, go ahead.
The FRS worker did meet with Bradley on Tuesday and offered to assist to fill out the NIMSCA application for him. And then she also assisted with a food assistance application and Medicaid, because we had learned earlier this week that the Medicaid for Estella was closed and their food assistance had been closed.
You mentioned in response to a question from Mr. Vernon that there was some deceit about where they were living. Could you flesh that out a little bit more for me, please?
Yes. So when I met with them on Friday, I had asked them what their plan was, where they were going, where they were going to go. They told me that there were a couple of apartments on North Center Avenue that they were looking at moving into. I had asked them if they could provide me with the name and phone number of the landlord so that I could verify that there was housing available for them. They told me that they would be going to Terry's home on Sunday to talk to him about staying with him temporarily until they could move into one of the 2 apartments that they were looking at. So on Sunday, they were supposed to get a hold of the on-call worker and let her know where they were staying and what their plan was. They did not get a hold of her, so she actually contacted them, and they told her that they were at Terry's home. They didn't indicate that they weren't staying with him. They just said that they were at Terry's home. I had reached out earlier in this week and asked them where they were staying. Initially, Bradley told me he was staying at Terry's home. And then later in the conversation, he said that they couldn't stay at Terry's home until the landlord called him. Again, I asked him for the landlord's name and phone number. He said he didn't have it. It was on a phone that was lost. He didn't even know the landlord's name or any contact information for him. He then said that he was house sitting for a friend and that he was staying in the friend's home. I went outside and talked to Ariel. Ariel told me they were staying in a camper somewhere in Waters. They couldn't provide an address. They couldn't provide a location. The only information I could get was that it was off a side road off of 27, somewhere between Der Miner's Party Store and the gas station in Waters. My supervisor had met with Bradley. Bradley reported that he had given the landlord $800 for a deposit, but still didn't know the landlord's name, or he didn't have a receipt. He didn't have any information to verify. So Lisa had asked him if he could take a picture of the street when he turned down the road to get to the home, and then take a picture of the home numbers. We told him we weren't going to come to the home. We just wanted to verify where they were staying. He wasn't able to do that. He called me and told me his phone was broken. He couldn't send me any of the information. He then called me on today's Friday, Wednesday, told me that the friend who he was staying with came home. He couldn't stay there anymore. So they had booked a room at the downtown motel. Then I went to the downtown motel to verify that they had stayed there. They said, no, there was nobody ever that stayed there by that name. So I contacted Bradley. I asked him where they stayed that night. He said that he had contacted the downtown motel. They were supposed to stay there, but their reservation got screwed up and they didn't have a room available. So they stayed at a hotel in Frederick. As to my knowledge, there's not a hotel in Frederick. He then called.
Say, Grayling.
Mr. Jones, you may not interrupt.
So then he had called and told me that he was with the landlord. I missed a phone call from him, but he sent me a text message, I guess, and said that he was with the landlord, that the landlord had talked to Terry, that Terry said that they could stay with him. So then I called Terry. Terry said that he wasn't sure who he had talked to. It was somebody that was with Bradley. They had told him that they could move into a trailer on North Center Avenue this weekend. There's not a trailer on North Center Avenue. They said it was a 3-bedroom trailer that for $800, everything was included. I actually went to the apartment complex one day this week that they said that they were moving into and knocked on a random person's door and asked them who their landlord was and if there was any apartments available for rent in that complex. There were not. And then I told Bradley I needed to meet with his landlord yesterday by 3:00, either in person or receive a phone call so I could verify any of this information. He told me the landlord's phone was stolen out of his vehicle in Detroit. It's been a lot of stories that there's no verification of any of it is true.
Thank you, Ms. Sullivan. Any counsel I'll get to you in just a minute, Mr. Jones. Any counsel have any additional questions for this witness?
No, Your Honor.
Sir.
All right, Ms. Hansel, your client appears to want to say something. Do you want him to do that?
Yes, if he feels compelled to say something, he might be able to clarify something.
Mr. Jones, what is it you want me to know?
So there is a few things that was wrong about that. So my phone did break and I'm stuck on my work app and all that they were wanting me to get verification stuff for. And I did have a booking problem with the booking site that I did, booking.com, and they were supposed to schedule among courts. Sorry about that. One of the people that I know had walked up and started talking. But as I was saying, they screwed up the reservation because they said that they had a room available when they didn't online. So when I went to do that, I went to say I was looking to see if there was anything towards Frederick, but if not, we're looking towards Grayling for something cheaper. But one of our friends did come through for us and got us a cheaper rate with AAA discount.
Okay, so Bradley, I guess what the court is just looking for at this point is we know there's been some confusion, there's been some misunderstanding. Perhaps there has been some things that appeared to be that you weren't being forthright on, but moving forward with this, as we spoke earlier, it's my understanding that we will just at this point deny the allegations. We have went over the petition, and we will ask this to be set for a preliminary or pretrial. Is that correct? That's what we agreed to earlier.
Yes, I think So
Okay. So yeah, we're in agreement. There's been some confusion and perhaps there has been some misleading information, but moving forward, we're seeking a plan from DHHS or to work with the prosecutor, to get this matter cleared up. Is that right?
yeah.
Okay. So I think that's enough said about the problems historically.
Thank you, Ms. Hansel. Mr. Vernon, any other witnesses or evidence today?
No, Your Honor.
Mr. Brown, witnesses or evidence?
No, Your Honor, thank you.
Ms. Hansel, any witnesses or evidence?
No, sir.
All right. Mr. Vernon, any closing statement?
We would simply ask the court to enter an order allowing the department to maintain the children in out-of-home placement and transition to either a family placement or another appropriate placement as becomes available.
Mr. Brown, any comments you wish to make?
Your Honor, it does appear that once Ms. Sullivan told them that she was going to draft this order, that they actually did take the children to her. As far as Ariel goes, I don't think it's going to make a big difference right now, depending on how her next case comes out with because she is currently incarcerated.
Thank you. Ms. Hansel, any comments?
No, as I stated earlier, Your Honor, we would waive the reading at this point. We'd ask for the court to enter a plea of denial and ask for this to be set for some pretrial. In the meantime, it's my intent to work with my client and with Mr. Vernon, and perhaps we can come up with some type of acceptable plea.
All right. Thank you very much. All right. It does appear that this matter has already been started. I believe that there is a continued preliminary hearing scheduled for June 16th at 11 o'clock in front of Referee Cooper. I'll consolidate this matter with that so that it may proceed at that time. And Ms. Hansel, if you wish to proceed as towards a plea or some sort of an agreement, you can certainly put that on the record at the time with Referee Cooper at that time. I do find from today's proceedings that there is sufficient evidence that a protective order is appropriate. There's reasonable cause to believe that the children were at substantial risk of harm, or that they're in their surroundings, that there was present and imminent risk of harm, and immediate removal was necessary given their very, very young ages, their vulnerability, the dirty conditions that they were found in, the fact that they were homeless and had been for quite some time, and the multiple efforts to obtain housing prior to the removal all indicate that they were in imminent risk of harm. The circumstances surrounding the ex parte order were appropriate for issuing of the custodial paperwork. It was consistent with the circumstances. Reasonable efforts were made to prevent or eliminate the need for removal, and I will adopt the record that was made by Ms. Sullivan as to all of the services that were presented do in fact meet the requirements for a reasonable effort. I do believe that there was no other remedy other than protective custody. The DHHS did try to get the relative, the grandfather who has two of the older children already, and they will continue to explore that, but it was necessary to take the kids at this time because he wasn't able to take the children immediately. And I do believe it is also contrary to the welfare of the children to remain in the home as they were actually kicked out of their house, were living in the car, and the car was not appropriate for them to stay in for a number of days. So immediate removal was appropriate at that time. I will then confirm the prior order that was issued yesterday, confirm the current placement of the children in foster care, ask DHHS to continue to work with the relative as to whether or not ongoing placement with him would be appropriate and under what circumstances that might be appropriate. And I'll move this matter to Referee Cooper's docket. The next scheduled court date for that then will be June 16th at 11 a.m. And we will continue this matter at that time. Mr. Vernon, is there anything else that we can do today?
No, Your Honor, no.
Any questions or anything else, Mr. Brown?
It appears that Ms. Johnson has had her hand up. I don't know what she wants.
Ms. Johnson, is there anything else I can do for you?
Would we be talking about my releasal after this, or how would that go by any chance? Because I really want to pay this fine.
Again,
I'm-
Ariel, that's a different
Yep.
case.
We're gonna talk about that just next, so if you stay right where you're at, I'll ask Mr. Brown to do the same. And then I'll find out whether or not we can get the friend of the court here within the next couple of minutes to take care of that process. If not, it would be later this afternoon that we would do that. I do see Ms. Kraus is here next, so let me finish this case and then we'll move to that case. Ms. Hansel, is there anything else from your perspective that we need to do today on this protective custody matter?
No, I believe that covers it for my client, Your Honor.
All right, so we will close the protective custody matter and we will turn then to the friend of the court hearing. Those parties that are not involved in that do not need to stay.
Thank you, Your Honor.
Thank you.
Ms. Johnson, if you'd stay, Mr. Brown, if you'd stay, Ms. Kraus, if you would stay. And let me switch court cases here. This is the matter of Terry Johnson and Ariel Johnson, file 24-19821-DS, set for a bench warrant arraignment from the friend of the court's office. Ms. Kraus is here from the friend of the court. Ms. Johnson, you are here on a bench warrant from the friend of the court for failure to appear on December 3rd of 2025 for a show cause hearing. Because you failed to appear at that hearing, a bench warrant in the amount of $1,200 was made by this court. Mr. Brown is here to represent you on that matter. Ms. Kraus, other than the arraignment on the bench warrant, is there anything else pending before with you for the court?
No, just in regards to the arraignment hearing.
All right. As to that hearing, Ms. Johnson, you have the right to be represented by an attorney if you cannot afford one. I believe Mr. Brown has already been appointed to represent you as to that. You have the right on a bench warrant hearing to have a hearing in front of me as the judge. You do not have the right to have a jury trial. At that hearing, you'd have the right to see, hear, and question the witnesses. You'd have the right to present your own witnesses and get a subpoena from the court to require your witnesses to appear and testify. You could testify or you could remain silent. You'd have the right to have the burden of proof be on the friend of the court's office to prove that there was a violation, such as failing to appear for a court order. And then you'd have the right to appeal. Do you understand the hearing rights that I just explained to you?
Yes, sir.
Mr. Brown, how would your client like to resolve this matter?
Your Honor, at this time, we would just stand mute. And I would ask Ms. Kraus if that bench warrant bond amount, is that based upon the 25% of her total outstanding balance?
At the time of when the bench warrant was issued, yes.
Okay. As far as bond goes, Your Honor, based upon the previous hearing, obviously she has not a dime to her name. I don't know if they get any kind of money from the state, or if her significant other is working currently, or they could set up some sort of a payment plan. But obviously they're going through a lot she's going through a lot right now and just has no way of posting any kind of a bond at this point.
Ms. Johnson, is there any information about this that you want me to be aware of?
I've just been really struggling, and I was kind of hoping I could be able to make a payment plan, because I was hoping to get out of here so I could get a job and get things going.
When was the last time you had employment?
It was at Qdoba, I want to say, but that was during my pregnancy. And they underpaid me and they overworked me, and it wasn't financially a good, stability for the family. So I had to depart from that job. And after I had my boy, they said I couldn't work for 6 weeks, and we got caught up behind that. But when I landed in here, that's why I was wanting to see about a payment plan and maybe getting released today so I could find a job.
Okay, you just had your son about 10 days ago, right?
Yes, sir.
All right, so you're supposed to be off work for 6 weeks, is that correct?
I'm supposed to, but I really think this fine matters to be paid, so I'm willing to work. It's okay.
All right. When did you leave Qdoba?
I left that it was right before I gave birth to my son, I want to say.
So you had your son in May, right?
5/26.
I'm sorry?
It was 5/26 of this year.
All right.
Because they messed up the date.
So you worked at Qdoba in up to May?
Yes, sir.
All right. Ms. Kraus, under those circumstances, what do you think we should do?
Your Honor, I guess I probably didn't get the information from the last hearing, so I apologize, but I'm not sure as to if there was income or something discussed.
No, there was not. It was a protective custody matter involving removal of the 3 small children, including the infant, from Ms. Johnson as well as her husband. And it involved them being evicted from their home and being homeless as part of the allegations of why the children were removed.
So she just gave birth to an additional child?
Correct. May 26th.
Okay, so there are obviously, in regards to a support recommendation with that, potentially a new recommendation should be done. I mean, there is an obligation amount of $302 and the balance is $5,811.35. But given that information, I do know that the court does have the information of a prior stipulation. Don't want to come across as harsh, but yeah, we do need to do something, obviously, maybe starting with a new support recommendation, adding the additional child potentially to this case, but I'm not sure what the status is of who the child's father or anything like that is.
I believe it was Bradley Jones. At least he's the one indicating that he was the father. I don't know that there's been any determination, and I don't know the status of the paperwork, birth certificate or anything like that. But he was the one in the court proceeding today indicating that the kids were his. So I think what I'm going to do is I don't believe that Ms. Johnson has any ability to make any payments at all right now.
Correct.
And I don't believe that it's really in her best interest with the child. She has a child that's 2, 1, and now 10 days old. Or less than 10 days old. So I don't believe that she's going to have any immediate access to funds to pay. So I'm going to set her bond at PR bond, leave it at what it was, but PR bond, so that she does not have to post any funds. I'm going to require her to give current information to the friend of the court about her circumstances, about where she's living and what her income levels are. And whether or not she can work, and if she can work, where she's going to work in the near future. And then I'm going to ask the friend of the court to prepare a new order as to child support as to all 3 children, unless there's some objection from Mr. Jones as to that.
I'm not sure in regards to, because the case with Terry, I believe, is her father, and this is potentially a guardianship case. I think it would just be refactoring with an additional child.
All right. Right now, Terry has the 2 older kids. The 3 younger kids are with DHHS in foster care. Those are the 3 that were removed. And so I don't know whether or not, and the DHHS is looking at whether or not Terry's going to get the other 3 children, but that decision has not been made yet. So if Ms. Kraus, if you would have contact with Ann Sullivan at DHHS, she's the lead agent on this as to where, and so in the near future, they'll be making a decision as to where the children are going to be placed, whether or not they go to Terry or not. Ms. Johnson, do you have an additional piece of information for me?
I just had a question, Your Honor. What's a PR bond?
A PR bond is a short way of saying a bond that doesn't require you to make any money, post any money up front. That means you don't have to pay any money to be released from the jail. So I'm going to do that for you so that you can be released today, but you're going to need to be in contact with Ms. Kraus because she's going to, in the future, once she figures out where the kids are going to go, she may need to update the current court order or the current recommendation as to what child support is based on where the newest child goes. If they go to your dad's house, then you may owe some additional money to your dad for the additional children that are there. So I want to get you out of jail while we can now. Ms. Kraus will figure out from DHHS where the kids go, and if there needs to be an additional or new order, she'll start that recommendation process. But you're going to need to cooperate with her as to what money you're making, what income level you have, where you're going to start work at, all of those kinds of things. Yes, ma'am. Go ahead.
But if I may, I was actually gonna let you guys know, I was thinking about working at the same place that Bradley works over at Amazon. So I don't know if that was a thing you guys should know, but I figured I'd let you know anyways. I'm just waiting to get out of here first.
As soon as you get a job, then you can tell Ms. Kraus where you're working. Until you get a job, it doesn't really help to say, I think I might get a job. Just when you actually do get a job, then you are required to tell Ms. Kraus where you're working and how much you're making and give her pay stubs and all that kind of stuff. Okay?
Okay, thank you.
All right. Ms. Kraus, do you have any questions for me about what we're doing today?
I think based on kind of what the synopsis of what you had just said, and I do appreciate that. I apologize for not being right up on what had happened.
We're good.
My thought would be potentially adjourning this out to the referee a few months, doing the PR bond, and then we could do a status of support, the additional child and the NA case as well, and maybe just kind of wait for those orders if that's the case, and just kind of keep an eye on things, but have it not fall off.
I think that's a great idea.
Be here longer?
Nope. That means you're getting out today, and they're going to refer things to the referee who deals with these things on a regular basis. And we're just going to monitor where the kids go and where you're employed at. And once we figure out all of those things, then Ms. Kraus can bring it back to my attention if she needs to in the future, or she can do that most likely start with the referee first. Mr. Brown, do you have any objections to any of that?
I do not, Your Honor.
Ms. Kraus, that sounds like a great idea. Let's do that.
Okay, thank you so much.
All right. Ms. Johnson, the friend of the court, Ms. Kraus will prepare some paperwork to get you out of jail today. It may take a little bit of time to get to you, but it will get to the jail today. I'll try to get it signed today, and we'll get you out of jail so that you're not staying in there over the weekend.
Thank you.
All right. That's all for today then. Thank you all very much. Appreciate your time.
Thank you, Judge.
Awesome.
All right, while we're waiting for the jail to have somebody else who call the next matter, which is State of Michigan versus Stephen Martin, file 26-44483-FY. Mr. Brown, is this your matter?
It is, Your Honor.
All right. Looks like we're here on an order to show cause for the alleged failure to appear for a status review on May 21st. On a charge of retail fraud, first degree. And it looks like we've received a letter from the Wolverine Community Library, the director, Susan Warner, indicating that on May 21st, Mr. Martin was at the library for 2 hours on a Zoom call for the court. Said that the host muted him, and when he hit the button to unmute, it would not work. So it appears that he tried to get on and was, for technical reasons, unable to do so. Is that an accurate statement, Mr. Martin?
Yes, sir.
All right. I will take off the order to show cause. Mr. Brown, do we otherwise have a resolution of this matter or not yet?
We do, Your Honor. There has been an offer made in this file to plead to an added count 2 of retail fraud in the second degree. with restitution of $1,128.18 for dismissal of count 1, and we would like to enter that plea today.
That is a correct statement of the plea, Your Honor.
All right. So the retail fraud first degree and the habitual offender second notice would be dismissed, and there would be a plea to the misdemeanor retail fraud second, which is a 1-year, $1,000 fine. Ms. Brucker?
Yes, Your Honor.
All right. Mr. Martin, do you understand all of that?
Yes, sir.
And is that what you want to do today?
Yes.
Judge, I'm sorry, Judge, I just double checked and it is up to a $2,000 fine.
Okay, up to $2,000. Thank you very much. So you, Mr. Martin, you understand that the maximum fine could be up to $2,000 under the reduced charge?
Yes, Judge.
All right. And knowing that, do you still wish to go ahead with the plea?
Pardon me?
Knowing that, do you still wish to go ahead with this plea? That is to admit your responsibility.
Yes, sir.
All right. If you do that, you'd be giving up your right to have a trial and all of the things that would happen at a trial. Do you understand that?
Yes.
Let me explain that in a little more detail to you. At a trial, you'd have the right to have a trial in front of a judge or a jury. You'd have the right to have your lawyer represent you at that trial. At a trial, you could see, hear, and question all the witnesses. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. At trial, you could also testify, or you could choose to remain silent, and that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. But if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
Knowing all of that, do you still wish to enter your plea today?
Yes, sir.
All right, I'm going to take some testimony from you. So would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
All right, go ahead and put your hand down, sir. Other than this plea agreement, has anybody promised you anything in order to get you to plead today?
No.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
The new charge, or the amended retail fraud second charge, would read as follows. It would say that on about July of 25 through April of 26 in the city of Gaylord and Otsego County, that you did in a store, which is Walmart, when it was open to the public, alter, transfer, remove, replace, conceal, or otherwise misrepresent the price at which the property was offered for sale with the intent to not pay for it or pay a price less than what the property was offered for sale, resulting in a difference of price being between $200 and $1,000. Is that what happened?
Yes, sir.
I assume that you went into the Walmart store here in Gaylord. Is that correct?
Yes, sir.
And what did you do that did those actions regarding the price of the things that were offered for sale?
It was just changing the barcode.
All right. And how many times did you do that? And what types of items did you do that on?
I did it several times. It was mostly food.
And the idea was to be able to pay less than the retail price for the food?
Yes, sir.
And you knew that you were defrauding or being dishonest with Walmart at the time that you were doing that?
Yes, I do.
All right. And this was all food that was offered for sale while Walmart was open to the public. Is that correct?
Yes, sir.
Do either counsel have any additional factual basis questions?
No, Your Honor.
No, Your Honor.
Either counsel aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
I am not, Your Honor.
Do both counsel believe I've complied with the court rule?
Yes, Your Honor.
Yes, Judge.
All right. I will accept the plea from Mr. Martin. It does appear that he went into Walmart here in Gaylord, changed the barcode and paid less for some items of food while Walmart was open to the public, and the food was offered for sale, and that amounted to be between $200 and $1,000. I believe he's given me a plea knowingly, intelligently, and voluntarily based on his answers to my questions, so I will accept his plea. Ms. Brucker, do we need to have a victim impact statement of this, or do you want to proceed to sentencing?
We can proceed, Your Honor.
Mr. Brown, do you agree?
Yes, Judge.
All right, Mr. Martin, I'm going to give both of the lawyers a chance to tell me what they think I should do for sentencing. And then after you've heard that, I'm going to give you an opportunity to tell me anything else that you want me to know before I decide what to do. Ms. Brucker, your comments?
This situation came to the attention of loss prevention at Walmart because they had noticed some suspicious behavior from Mr. Martin. They caught him essentially in the act in one incident, switching prices. And then when their loss prevention team went back and looked at old tape, they found 18 other times when he had done this. So essentially, he first was cited for retail fraud third because we just had the one incident, but once we aggregated all the other times, the full restitution amount is the $1,128.18 to Walmart. His criminal history, he has a felony conviction from 1998 for criminal sexual conduct, but does not have anything else after that. Typically, on a first time retail fraud conviction, I don't ask for anything but probation, but I think given the number of times he came into the store and intentionally did this, I would ask for the court to place him on probation, to order him to do an economic crimes class, to order the restitution, and I would ask for the court to impose some upfront jail on this matter. And that's all I have, Judge.
Thank you. Mr. Brown, allocution?
Just very briefly, Your Honor. Mr. Martin is 66 years old. He does have some health issues. He's had a couple heart attacks. He has 3 stents currently. I believe he needs another stent. He lives at home and cares for a disabled woman who lives with him. He is currently taking medication that has really racked up a lot of bills. He is probably $80,000 in debt between his medical bills, medications, things like that. To be honest, he's not making excuses. This is not something where he is trying to skirt responsibility for what he did. He knew it was wrong. Unfortunately, it is one of those kinds of cases where he just, quite frankly, felt desperate. Medical expenses are extraordinary anymore, and there is a lot of help around this area, but for whatever reason, people generally don't look for that help before they just get desperate and try to take things, and hopefully they don't get caught. But that is usually not the way it works out. And so I think he is very embarrassed for doing it. Again, I mean, he went 30 years without a criminal conviction for anything. So the times caught up with him, and he made a really bad decision, several bad decisions that added up and ended up in this charge. So I would ask the court to take all that into consideration when fashioning a sentence in this particular case.
Mr. Martin, you have the right to address the court prior to my decision. What would you like to tell me?
That I'm very sorry for doing that. My bills just got overwhelming. I didn't know which way to go. And now I'm starting to put things together. I got a lot of my medical bills on monthly payments. The lady I take care of, she is going to start paying the gas and electric bill, which would be tremendous help. And that's it. I'm just sorry for doing it. And I apologize to the bottom of my heart. It was a wrong thing to do.
Well, thank you for saying that, Mr. Martin. I appreciate that. I see that you live in the Wolverine area, but I'm sure that you travel into Gaylord on a regular basis. Would that be a correct assumption?
Yes, sir.
I think you'll find
all my doctors are in Gaylord and Petoskey.
Well, I think that you will find in Gaylord that if you ask, people will give you the shirt off their back. There are programs set up on a regular basis at the food pantry. There's a program through one of the churches downtown that has a meal either every week or every other week. There's a food delivery truck that comes to the E-Free Church on a monthly basis. We are looking for people to give things to when they can't make it on their own. So to take food this many times and in this amount tells me that you really weren't looking for help. You were out there to help yourself. And there really isn't a nicer way to say it than you resorted to being a thief. Now, you may have had good intentions, or you may have thought that you had no other alternative, but if you'd have asked anybody, they'd have told you. And I literally mean anybody. Anybody on the street would tell you that here's where you can go. It's that well known that, and this area is known for those kinds of programs. So if you'd have just asked anybody, they'd have been able to tell you. And to do it 18 times tells me you weren't trying to fix the problem other than trying to steal your way out of it. And that's simply not acceptable. I mean, one time because you're starving, it's not right, but I can at least understand it. But 18 times, that's just practice.
Yes, sir. I went to the food pantry yesterday, as a matter of fact. I am finding
And how
out
was
that
it?
people are trying to help me.
Did you get what you needed?
Yes, sir, I did. Very grateful
And you-
for them.
Yeah, it's a great program, and I'm glad that you're taking advantage of it. But it just goes to show that you've got to be willing to reach out and ask. If you're too proud to ask, then you get yourself in trouble, and that's where this comes in.
Yes, sir, I'm finding that out.
All right, I'm going to put you on probation for 6 months. There's a probation oversight fee of $180 for that. There's a crime victim fee of $75, a justice assessment of $50. There's restitution in the amount of $1,128.18. It's $200 in court costs, $100 in fines, and a local charge of $15. Let me add all that up to you. It's going to be expensive meals that you just bought. With the restitution, it's $1,748.18. You can pay that over the course of your probation. You may perform community service in lieu of some of those fines and costs at the discretion of the probation office. You must enroll in and complete an economic crime course. That's a video series that the probation department will help you set up and monitor. Do you have a disability, sir?
Do I have a what?
A disability so that you're not able to work?
Just a heart problem right now. I have restrictions in 2 of my veins. They're trying medication to see if that works first. And I've been on that for 3 weeks, and so far it's not doing nothing. So I can do light duty things.
Yep, and that's what I'm contemplating. I'm going to require you to do 15 hours of community service work. I'm going to put down light duties due to heart issues. And I'll let the probation department work with you on that to see if we've got some of those available. I think we probably do, but I want to check to make sure.
Okay.
Then the issue becomes, do I put you in jail or not?
Pardon me?
I said the issue becomes, do I put you in jail or not? Are you at the Wolverine Library right now?
No, I am in the Gaylord Library.
When would you like to report to the jail for 3 days? Today or early next week?
It'd be next week. I have to take the lady that's living with me to the doctor Monday. She gets shots in her eyes. Horrible.
All right. So you want to report on Tuesday?
Sure. For 3 days?
Yep. So
Okay.
that'd be report June 23rd, that'd be the 9th at 6 p.m. That'd give you credit for the 9th. You'd be there the 10th and you'd be getting out on the 11th, the morning of the 11th. That'd be your 3 days.
Okay.
You have any questions about the court's order?
No, sir.
That's all for today then, sir. All right, I see Mr. Wadewski's been waiting patiently at the jail. We'll call his matter next. This is the matter of State of Michigan versus Timothy Wadewski. There are two files. The first is 26-44590-FY. Second is 26-44601-FY, both set for status review. Mr. Trush.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Wadewski. This is date and time for a probable cause conference. I spoke to Mr. Wadewski just yesterday. I was able to drop off all his discovery packs for him when we discussed the preliminary exam. When we had discussed it, I think he was in favor of waiving it, but Mr. Wadewski, I'm going to ask you directly, do you want to waive the exams today, or do you want to schedule them?
I'd like to waive them, Your Honor, or sir.
All right. The process for doing that, Mr. Wadewski, is I have to make sure that you're doing that knowingly and intentionally. It sounds to me like you've talked with your attorney about what happens at a preliminary examination, and you know that you have the right to have it, but that you can give it up if you do so knowingly, intentionally, and voluntarily. Is that correct?
Yes, Your Honor.
And after consultation with your attorney, can you tell me that you are doing that voluntarily and nobody is forcing you to do it or threatening you to do it in any way?
I'm doing it on my own with nobody's threatening me or making me do anything under.
All right, that sounds good. Then the form that is used to do that requires a signature. Do I have your permission to sign a waiver form in both of these cases?
Yes, Your Honor.
All right, I will do that now.
Your Honor, you have my permission as well.
Thank you. Ms. Brucker, do I have your permission as well?
Yes, Your Honor. Sorry, I was muted.
Thank you. Mr. Truce, do you waive reading of the information?
We would, Your Honor. We would waive a formal reading and continue to stand mute.
Ms. Brucker, any objection to bond being continued?
No, Your Honor.
Your Honor, in regards to bond, I had a question for the court.
Go right ahead.
Is he at present being held on the on a detainer from the drug court? I see Mr. Hamlin's here. He might know the answer to that better than.
I don't believe so. Mr. Hamlin?
No, Your Honor, he's not.
There are pending sanctions, but we've not addressed those yet, and I don't believe we've done anything to address his bond in the drug court process.
In light of that, Your Honor, we would continue to ask the court to consider a reduction in bond or a 10% provision in the bond. Again, while I understand that there's some sanctions there and ultimately they may kind of be driving the bus in regards to what happens in all of this, or maybe not. I would continue to suggest to the court, from what I have seen, there appears to have been some mental health issues that were a significant factor in this. those issues appear to have been addressed. And he appears to be in a stable place now. So I would ask the court to reconsider the bond.
Thank you, Mr. Truce. Ms. Bruker, any comments?
I think this was also requested at the hearing on the 28th. And again, I don't think anything has changed from the prior hearing to merit a bond reduction. Mr. Wadesky is currently charged with fighting with various police officers while at the emergency room, among other things. And the safest place for him in the community is currently with the bond set where it is.
All right, I am very familiar with Mr. Wadesky. I'm very familiar with his, and that's because I've been his drug court, sobriety court judge for the last year and a half. And I truly like Mr. Wadesky when he's doing well. Unfortunately, this is not my first go around with his mental health deterioration and his fighting with officers and others when he does deteriorate. And it tends to happen relatively quickly once he's out of a very structured environment. And so my concern is that even if I were to, even though I think you're correct, Mr. Truce, that he is doing well now in the jail in a very structured environment, very soon thereafter, we would have, it's highly likely we would have another meltdown, for lack of a better term. And he and members of law enforcement and anybody else who happened to be in the way that day would be in very serious trouble. Mr. Wadesky is not a nice man when he is not under the control of his medications. And he has gotten increasingly violent as the time has gone on, noted by the new charges in these two particular files. So for all of those reasons, and because I agree with the prosecutor that nothing has changed since the last time, I'm going to deny your request. All right, that's all for today. Thank you.
All right, you're Tiffany Nicole Diane Tincher. You live in Three Rivers? You got arrested on March 31st at 11:40 for operating while intoxicated. They used to just call it drunk driving. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record and requires that your license be suspended. You don't have much baggage on your driver's license, but this isn't going to help. Apparently the plea offer is the prosecutor will not charge driving with a high blood alcohol level if you plead to operating while intoxicated. Is that correct, Mr. Bush?
Yes, Your Honor, that's correct.
Are you going to do that, Ms. Tincher? All right, let's take a look at your ticket. This was, I said, 11:40 at night, Michigan Avenue and Wood Street. That's by Paul's Pantry, not very far from where you live. You heard me go through the advice of rights probably 2 or 3 times this morning. You understand that you're going to give those rights up by entering this plea? Did anyone threaten you to get you to plead to this or promise you anything? All right, were you driving a car that night, a 2012 Chrysler? Where were you going? Had you been drinking? Yes. What did you drink?
Mixed drink.
What was in it?
I know it's just called MXD. It's like a fruity drink, I want to say.
Impact disease?
Once again, I'm not culturally up to speed. Ms. Stoll, what was the blood alcohol here? Oh, this is an ordinance case. John, what was the blood alcohol here?
313.
Oh, my. Oh, boy. Here's like 10 or 12 more cases. You drank a lot of it. What else were you drinking?
99.
All right.
Little
Oh, it's a little, come in little bottles, not the Toto song 99. All right. Well, obviously you drank a whole bunch. So were you going to Paul's Pantry to get more alcohol?
Yes, Your Honor.
Oh, boy. What do you do, ma'am?
Right now I stay at home with my daughter.
Who else lives at your apartment?
But just me as of right now, but her dad at her that night.
All right. Is that where you were drinking at home?
Yes, Your Honor.
All right, we gotta get a handle on this. There's some red flags. Drinking by yourself. This is a very high blood alcohol level. At 3.2, they have to take you to the hospital. It's almost poisonous. Well, it is poisonous, but it's almost dangerously deadly. What do you do, Ms. Tincher? Do you work someplace?
No, but this.
I mean, what kind of work have you done?
I've driven for Amazon, I've worked at Walmart, I've done CNA. I just have my daughter and, he let me like stay home with her and he pays the bills.
How old's your daughter?
She's almost 2.
Okay, he being your daughter's father?
Yes.
She's back at that pivotal university.
Yeah, we're gonna wanna find out about that. How old are you?
I'm 23.
Well, I'm gonna set this for something called plea. Well, we got the plea. I'm gonna set it for screening and sentencing. I wanna know more about this. This is spooky stuff. And we may have some real issues we need to get at. You don't have any criminal history to speak of. In fact, you have none. You have a couple minor little traffic things, but driving down even just a few blocks like this at a 313 is very dangerous. So John, let's pick a date that works for sentencing for you. Boy, this is scary. I've set several things for July 6th and none of them have made it onto my calendar yet. So I can't really tell how dense it is, but I'm gonna be gone a little bit in July. But are you available Monday, July 6th?
I have a district court sentencing, I'm not sure, you were Judge P at 10:30 already that day?
Yeah, I think that's me. All right, Ms. Tincher, I'm really gonna wanna know more about this. I'd like to get a release from Pivotal, see what's going on.
Okay, I'm supposed to start on the 11th.
Start where?
Therapy at Pivotal.
Very good. I wanna know more about it.
Honestly, I understand. I do want to get help. I know that it was that, and I feel.
All right, well, fortunately, you didn't hurt yourself or someone else. You're gonna be there for your daughter, but you need to be there in better shape than this. Or you take her out, we'll plug her into the probation department. I'll
What
see.
time do we actually set it for on that night?
July 6th at 11 a.m.
11.
Thank you, Your Honor.
All right, thank you. Good morning, Mr. Wood. Can you hear me?
Yes, I can. Good morning.
Those people were here waiting on his case. Would you let them know we're about to do it? This is file 26986SM, People versus Seth Wood. In that case, the defendant is charged with aggravated assault. And that allegedly occurred on May 18th. The complaining witness is Elizabeth Conway, I believe, and Gavin Edit. File number 26987SM alleges domestic assault on May 13th, and the complaining witness in that case is Nicole Anthony. Mr. Paul Gibson is here. And Mr. Wood, you're back at the jail. You were here, I think, for a hot minute, and I mean hot, back there in the lockup. And I didn't want to leave you in the lockup all morning while we dealt with this. So I had him take you back out to the jail so we could do this remotely by video link. Eddie Stoll is here from the prosecutor's office. Ms. Stoll, what is the plea offer here?
Your Honor, the offer is as charged in both files.
Mr. Gibson, what's your client wish to do here?
It's my understanding that he wants to accept the plea offer and plead today. He has a pending parole violation. His parole agent, I believe, is Jeb Miller.
All right, Mr. Wood, let's unpack this. Let me pull it up. In the first incident, it is alleged that on May 13th, you assaulted Nicole Anthony, someone you had a dating relationship with. Domestic assault is commonly known is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. Now, a few days later, you got charged again in a separate complaint. That is file 26986. That alleges that on or about May 18th, that you assaulted Elizabeth Conway and did inflict an injury upon her, but less than the crime of murder. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. So you're going to plead to a domestic assault on Miss Anthony and an aggravated assault on Miss Conway. Is that correct?
Yes.
Do you understand that if you do plead to these charges, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson is here with you, or you could hire an attorney of your own choosing if you wish. If you had a trial, you'd have the right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand on your own behalf and testify, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes.
And
All
I
right.
did explain that this could be the basis of a parole violation. If
Yes.
he's found guilty.
These could be a basis for violating your parole. Either or both of these could result in evidence against you in a parole violation by your parole agent and the parole board. Do you understand that?
Yes.
And that doesn't change your mind about entering this plea?
No.
All right, let's talk about the Elizabeth Conway matter set first. Elizabeth Conway is a woman that's in Three Rivers. She got some serious mental health problems. There's open warrants for her arrest. There probably were on May 18th. How did you know Elizabeth Conway?
I know her from my dad's house.
And who's your dad?
Delmerwood.
All right, and so she sometimes goes over to Delmer's house?
Yes. Used to.
Well, did you get into some disagreement with her?
Yeah, we were at car wash and she was rambling on saying that I stole her credit cards and was taking all her money. And then she proceeded to say that I killed her son. And then since I killed her son, that she was gonna kill the kids that I had with me, which were Nicole's kids at the time.
So you punched her in the face?
I slapped her, yes.
Apparently it caused a pretty good injury. She is delusional. She's accused me of one thing or another.
Yes, I know it wasn't right. It wasn't. Yeah,
No, it doesn't give you the right to punch her in the face, and she went to the hospital as a result of that. All right.
Yes.
Let's talk about the other matter with Miss Anthony. That's your girlfriend, isn't it?
Ex-girlfriend, yes.
All right, ex. So let's talk about this one. This happened on May 13th in Three Rivers. Where did this happen?
The house. We were living together.
Which was where?
242 South Main.
All right. You and Miss Anthony got into some sort of disagreement?
Yes.
Tell me what happened.
She called me. She said she called me by a wrong name. I got mad. Hit her with a pillow. She started swinging at me, so I grabbed her and to calm her down. And she headbutted me a couple times. I let her go, and that was about it.
All right, you hit her with a pillow and then you grabbed her?
Yeah.
I don't have any facts in here. Is that sufficient for you, Abigail?
Yes, Your Honor.
What are you on parole for?
Possession of felony firearm, possession of ammunition, possession of meth.
So you did a 2-year flat sentence?
No, I had two. I was on parole and I called charges.
All right, well, I'm gonna get some info from your PO before I sentence here. I'm not sure what to do, so let's find a date that works for Mr. Gibson. Paul, are you available on Monday, June 22nd at 10:30? We'll say 11. Does that work for you?
Yes.
Your Honor,
Yes?
so are you ordering a pre-sentence investigation?
No. I'm just gonna talk to his parole agent, Mr. Miller, see what his consequences are.
I think that might actually be appropriate here, a PSI, because the defendant was on parole at the time of the assault. It seems from what I've gathered between the two police reports that his behavior is becoming more aggressive, so maybe a PSI would shed some more light on that and give us a better idea of what's going on with him.
Well, it's not the kind of case we're gonna put him on probation because he's on parole. And these are likely gonna result in a return to prison. Perhaps they could give us some insight, but there would be a PSI in the felony case, which I could review and talk to his probation agent. There isn't enough time to do a PSI between now and June 22nd. And I'd like to get this moving, so for his benefit. So it probably is a good idea, but it won't work, and I don't think he's gonna be placed on a district court probation. But I would like victim input, police report in both cases. And I'll get input from Jeb Miller. All right, Mr. Wood, it's time for lunch. Friday is, I think, lobster and prime rib day. His sentence will be here live at the courthouse at 11 o'clock on June 22nd. All right, you had some friends here waiting all morning for you, Mr. Wood. You're good to go.
Thank you.
All right, Tina Watson, I'm sorry, someone always ends up being last. Today it was her. This was part of your legal education. You got to watch all the other pretrials and arraignments today and think, there's a lot going on around here. Let's talk about your case and just your case. This is file number 26946 SM. You're Tina Marie Watson?
Yes.
You're alleged that on or about May 16th, you assaulted Brianne Rittenauer, a former resident of your household. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Prosecutor has offered to do the deferral, whereby I would place you on a probation, send you to women's anger management or domestic violence class, and if you successfully complete the class and otherwise comply with the terms of probation, the charge could be made non-public. It is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. Do you understand?
Yes.
You've signed the advice of rights and you heard me go through it probably 4 times. You could probably recite it back to me, but do you understand you're giving those rights up by entering this plea? Who is Brianne Rittenauer to you?
My nephew's girlfriend.
They reside in your house?
They did.
Who owns the house on Second Avenue?
My brother.
All right, what's your name, sir?
Wilburn Watson.
Wilburn Watson. And you live there with him?
Yes.
So this was his son's girlfriend?
Yes.
Abby, you're here for the duration. We burned out your intern. She got bored and left. So I've had enough of this. You're stuck with me through the whole thing. So I appreciate it. All right, so it looks like you lost your temper with this lady on May 16th. And tell me what happened.
She was calling my boys, my 13 and 14-year-old boys, dumbass.
Call him what?
A dumbass.
Okay.
So told her not to call them that. And she said, turn around and said, they are dumbasses. There you go. I lost my temper.
All right, it said you hit her and choked her and.
No, I choked her, not hit her.
All right, did choke her. Is she out of the house now?
Yes, she is. She's been calling to talk to my brother about the no contact to be lifted.
Yes, it's my understanding that it's been indicated to me by the defendant and her brother that she, Brianna, I guess Rittenauer, has contacted the prosecutor's office asking that the no contact be lifted. I can't verify that, but the brother explained that it's possible that they may need to move back in. So if the court, they are asking for the no contact to be lifted, but if it can't be today, they would be asking for that at the time of sentencing.
I'd rather wait till the time of sentencing. I don't know enough about it. Do you have any information regarding that, Abby?
Your Honor, the victim did call, it looks like on May 20th, according to the notes in the file from Nicole. She said that she spoke with the victim and that the victim had some questions about the no contact order, but it's unclear whether she actually asked that it be lifted.
All right, well, we better find out. I'm gonna do this one sooner than later. The police report and victim input. Was anybody drinking?
No.
That's a plus. Somehow I shut down my calendar. Judge Patterson doesn't use this calendar. I use it 50 times a day. Today is June 4th. Yeesh. I'm gone. Oh. Did I just set you for some stuff for
the? Well, yeah, you set me for. There was
July
June
6th.
22nd for Wood sentencing 11.
All right, June 22nd. Let's set this for June 22nd at 11. All right, Ms. Watson, I don't think you got much of a criminal history. What I'm envisioning, I want to hear from the victim. I want to see the police report. I'm going to put you on a probation, most likely, with a condition that you go to the Women's Anger Management Program. Alcohol doesn't appear to be a factor. That's a plus. All right, thank you for your patience. I'll see you on June 22nd at 11 a.m.
Thank you.
Yes, sir?
Brianna and my grandson,
Yes.
they have to be out of the place that they're in Indiana by the 11th.
Well, they need to contact the prosecutor with more definite information.
I can have her call today if you would like me.
Yes.
I'll get a hold of her here when I leave the courthouse and have her call you guys because her mom is moving. So she won't have a place down there to stay and she has to come back to my house. Okay.
All right. All right, you're good to go.
Thank you.
Oh my lord. My headset is off. That's right. Hear yourself. What's going on? What's not supposed to happen? Ladies and gentlemen, I'm your lone wolf Houston. We're getting together tomorrow morning at 11 a.m. noon Eastern time. And what the heck is going on here? I'm so confused. Listen to mom. I'm out. I don't know what's going on. Rolling credit. Oh my God. I understand what was happening now. I was hearing the stream from my cell phone. That's crazy. Had me all messed up. Ladies and gentlemen, I'm your lone wolf Usul. I'm a nutty guy who finds court cases and brings them to you every single day of the week except for Sunday. But we have premieres on Saturday and Sunday night at 8 p.m. at Central Time. We're going to do a weekend review tomorrow around 11 a.m. Central Time. And I'll be back with you then in about 12, 13 hours or so. I want to thank everybody who came out tonight and all my friends. Most especially, I want to thank Just Call Me Stephen Kerfuffler, Charlene Tutt, Michelle Goes Live, OSG, all you crazy people, Felix, Charlene. Oh my God. Y'all see, I had to change over there to remember the name. I can hide nothing from you people. I can hide nothing at all. Sorry the end was all messed up. It's the nature of me being live. It happens. I love you all. You know? See you next time. Like 13 hours. I am your lone wolf Usul. And I am out. Friends, sometimes you eat the bar, sometimes the bar eats you. You know, that rug really tied the room together. Time for a white Russian. See you later.